Now, the federal budget continues to spark fierce debate over a property tax change, including concerns about what some have called a widow tax. But beyond politics, it raises very practical question. When someone dies, could the family be left with dealing with tax consequences, ownership issues, or disputes they never saw coming? To help us understand what it all could mean from a wills and estates perspective, we're joined by Attwood Marshall Lawyers, Estate Litigation Senior Associate Duncan MacDougall. Duncan, welcome to the studio.
Thanks for having me again.
Yeah, great to have you back in here. Now, there's been a lot of noise about the government's proposed tax changes and the recent backflip over concern about what could happen on death or divorce. At a high level, what was the issue that caused so much concern?
Yeah, so it's easy just to bring in an example with
Yes.
that. So let's say Jack and Jill own an investment property together. All of a sudden, Jack passes away. That property is then transferred to Jill as the surviving owner through law of survivorship. Presumably, they own this property jointly. If that's later sold, then there was some reforms around how that CGT was going to affect. And the main issue was that whether current concessions were going to be grandfathered into existing investment properties.
Mm-hmm.
And there's some backflip in the government, and that was what raised this widow's tax per se for poor Jill, to say, well, why shouldn't this continue, or why shouldn't the current status quo continue in my favor?
All right. So for listeners who own an investment property with their partner, why can a death in the family suddenly become not just an emotional event? I mean, it's a tax and estate planning event as well. It's such an emotional time. This can just add another layer.
Yeah, it's one of the last things people want to even consider, especially after the death of a family member or a loved one. It's a very emotional time as well, but it's important just to be aware of how things are going to play out. And I'd say get that advice from an estate administration solicitor who will guide you through that process, because realistically, they're going to give you a bit of a snapshot or a bit of a strategy on how to deal with these things as time goes on, because you've got a number of different things to deal with the passing itself. So, but it will always trigger all these things, all these considerations, particularly around whether or not the deceased own investment property. And that's typically where we see these tax issues come into play, or if they own shares, or because when somebody passes away, unfortunately, these investments doesn't mean that they stop. They will still earn an income. And then when it's time for tax to roll around, and when that's in the process of being administered, then we'll have to consider those sorts of things as well.
Okay, can I throw this scenario at you? If there's and we quite often can see this and between, and they don't have to be related, but we'll say they're related. So if a few sets of couples are involved in a investment property and one of those members dies, but everyone's name is in it, is it a simple case then of striking off the name, but then you're taxed on the increased percentage?
Yeah,
how does that work?
I think it all comes down to the starting point in all of that is, okay, well, what does the will say? What's the terms of the will? Second is, how is that property actually owned? So it depends on how that ownership is structured. So to give your example consideration there, I mean, if we're talking about multiple people owning a property, whether it be a couple or multiple people, if it's through joint tenants, then that'll pass through what's called the law of survivorship, which is simply lodging the death certificate with the titles office. They remove the deceased name. The other person becomes the sole registered owner. Whereas if you're talking about tenants in common, everybody's going to have a fixed share. So that could be 50-50. That also could be 60-40. And that fixed share will be distributed and dealt with as part of their estate plan and as part of their the terms of their will. So when we're dealing with the estate planning aspect with these things, it's the first point of call. Well, a lot of times people don't even know how their property is owned. So that's the starting point to see, well, how is this actually going to play out when one or both of us pass away?
Yeah, this is raising so many different questions. So do you make sure that if you've got property and you want it to go to your partner, make sure that your partner is listed as an owner would be one of the first things to do.
Absolutely. That and even it's not just as simple as saying, well, I wish my son to receive the benefit of my investment property, or my investment property is going to be distributed to my son, for example. There's a lot of things that'll go into that, primarily around, well, is there a mortgage over the property? Is there any sort of tax consequences that are going to happen there? Primarily, if they're going to, generally they have to sell it within the first 2 years to take consideration those capital gains tax concessions. Whereas if they retain the property, then later sell it, is it better off for everybody that the property is just sold? In which case, then the beneficiaries will have to be liaising with the estate, the executor in those things. So it's all these things to take into consideration when estate planning. And I tell people all the time, have those conversations early on to see whether or not those beneficiaries may be in a position to deal with it.
Yeah, that was going to be my next question about timeline. When this happens, we talk about it being an emotional time when a family member passes, particularly if we're dealing with the passing of a family member here and not just an acquaintance. So how long should you wait till you act?
Yeah, well, I'd say not to leave it too late. I mean, generally an executor will have what's called an executor's year to wrap up an estate. But that being said, it's important to jump on these things early on because particularly around how this property, for example, if you've got property shares, how these things are going to be distributed, most times you're going to need what's called a grant of probate to administer the estate. So there's court processes involved as well. Before you can deal with the titles office, they're going to want some sort of authority saying, yep, that's a valid executor, and yep, that's a valid will. Without that, we're kind of stuck. So when you're dealing with this property, and there could be tenants in there as well, so there's all these sort of things to take into consideration.
Yeah, you know what? One thing going through my head when you're answering these questions is just make sure you get the right advice.
That's it. Yeah. And I would say get it early. You know. Sometimes people take the position, well, they can administer the estate. If it's a very simple estate, if it's everything was owned jointly, mom and pop situation. But when you got situation like blended families and things like that popping up, could very well be risks of claims as well. So you don't want to make any sort of early distributions without having at least knowledge of the time limitations for people to bring claims against the estate as well.
Okay, so, and that could be the case of, anecdotally, a couple divorce, 15 years later, there's another marriage, and then another 10 years later, there's a death, and all of a sudden, the person from 25 years ago can come knocking.
Exactly. Or yeah, you know, you may have excluded a beneficiary. That may have been what your intentions are, but there's certain legislative requirements there where they can say, well, I haven't been adequately provided for, and bring a claim against the estate, in which case sometimes we see issues where things are dealt with. They want to wrap things up within the 6 months, but they have until the 9 months from the date of death as well to bring any sort of claim. So it's not just a snap of the fingers and everything's done all at once. It's making sure everything's considered.
Can I ask you a question then? If you're coming from someone from the outside and you believe you can make a claim, but you didn't know about the death, can you look back and come in and say, or is it once it's all sorted and dealt with, are all your avenues closed?
Not necessarily. There is an avenue where you can apply leave to the court for an out-of-time application. They don't come up very often, however, because the court does not like to. It's a hard bar to get across, I would say. So it's important just to make sure. I mean, those rare circumstances where perhaps you didn't know or but failing just to act on anything and just leaving it to the last minutes, not going to be in your favor.
No. All right. Well, and as we said, go and get legal advice on this. Duncan, really appreciate you coming in because it's a topic that I know a lot of our listeners will certainly be concerned with, thinking about, and top of mind. So just, I think to wrap up, the big overwhelming message you want to take away from this is that jump on this early. Yeah,
absolutely. And I mean, this whole issue about tax as well. I mean, Australia is one of these places, unlike the UK, for example, there's no inheritance tax in Australia. But where they get you is these things like superannuation distributions to non-dependents and CGT, which I would say, in a way, I would say it was almost like an inheritance tax, but they don't frame it that way.
No, you wouldn't want to word it that
So
way.
it's just making sure that you're across those things, get that advice early, and make sure you're across your rights and responsibilities.
Excellent stuff. Thanks for joining us this afternoon.
Thanks for having me.